In 1975, 3 young lawyers in Mobile, Alabama filed a lawsuit on behalf of every black resident of the city. They argued that Mobile's election system was designed to ensure that black voters could never elect a candidate of their choice to city government. Their argument won at the district court level, but lost at the Supreme Court. Congress then spent 2 years rectifying the Supreme Court's decision, resulting in a set of amendments intended to strengthen the Voting Rights Act of 1965. 46 years later, the Supreme Court has picked up where it left off. I'm M.I. Reynolds, and this is the People's Podcast. Mobile had been governed by 3 commissioners elected at large rather than by district since 1911. In a majority white city with racially polarized voting, this guaranteed that black voters could never elect a candidate of their choice. No black person had ever been elected to the Mobile City Commission. In 1975, 3 Mobile attorneys, Greg Stein, J.U. Blacksher, and Larry Menifee, filed a class action lawsuit on behalf of Wiley L. Bolden and 13 other black Mobile residents with support from the NAACP Legal Defense Fund. They argued that the at-large system produced discriminatory effects regardless of intent. A letter written by a Mobile lawyer in 1909 explicitly advocating for that outcome was admitted into evidence. Chief Judge Pittman of the Southern District of Alabama ruled for the plaintiffs in 1976. But in 1980, the Supreme Court reversed this decision. The court held that Section 2 of the Voting Rights Act required not just that discrimination was the end result, but that there was proof of intention to discriminate. Evidence of discrimination now required, essentially, being able to read the minds of legislators and officials. Justice Potter Stewart, speaking for the majority opinion, wrote that the legislative history of Section 2 makes clear that it was intended to have an effect no different from that of the 15th Amendment itself. Justice Thurgood Marshall dissented, writing that the ruling effectively eliminated the use of the vote dilution theory under the 15th Amendment. Congress agreed with his interpretation. The Senate Judiciary Committee held hearings on the Voting Rights Act, during which J.U. Blacksher testified. This record established explicitly that Section 2 was intended to cover discriminatory effects per se, not just recorded intent to discriminate. President Reagan signed the 1982 VRA amendments into law. The standard set by Bolden was reversed. 4 years later, the Supreme Court decided Thornburg v. Gingles, using a 3-pronged test for Section 2 claims that Blacksher had proposed and that Menifee had helped develop. This case codified the idea that voting discrimination was based on end results rather than proven intent. Under the amended Section 2 and Gingles framework, minority communities across the South gained congressional representation. In Alabama specifically, a federal court found in 2023 that the state's congressional map likely violated Section 2 and ordered a new map to be drawn. Black voters in Alabama elected a second black congressman for the first time in decades, Shamari Figures. The system built by Stein, Blacksher, and Menifee was working. On October 15, 2025, the Supreme Court heard oral arguments in Lousiana v. Callais. The case questioned whether Louisiana's court-ordered majority black congressional district was itself an unconstitutional racial gerrymander. Let's listen to President and Director Counsel of the NAACP Legal Defense Fund, Janai Nelson's response to Justice Elena Kagan's question about what would happen to minority voters if Section 2 stopped working.
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives have been elected on those same districts. So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process, but it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
Justice Alito, writing for a 6-3 majority, struck down Louisiana's court-ordered majority black congressional district and reinterpreted the Gingell's framework, effectively requiring litigants to separate race from party in states where the evidence consistently shows they are inseparable. In her written dissent, Justice Kagan said, "The Voting Rights Act was, in the words of a Senate report, born of the bitter and bloody struggles of the civil rights movement. Today the court makes it all but a dead letter." The majority's approach returns Section 2 to its pre-1982 state, to what Congress rejected in the wake of Mobile v. Bolden. Within days, Alabama reinstated their original congressional map that had been found to have violated Section 2. Greg Stein still practices law in Fairhope, Alabama. J.U. Blacksher lives in Birmingham, Alabama. The plaintiff who started it all, Wiley L. Bolden, is part of history now. These lawyers built something that lasted 40 years. They lost at the Supreme Court and then helped Congress to fix the law. Last month, the Supreme Court undid their efforts. Justice Kagan wrote that only Congress can say the Voting Rights Act is no longer needed, that judgment belongs to the people, not the court. Alabama's contested map will be used for the special primary election on August 11th, called by Governor Kay Ivey just days before Alabama's primary this past Tuesday. The NAACP Legal Defense Fund is actively pursuing legal challenges and advocacy at naacpldf.org. The People's Cooperative will continue covering this story. You can find that reporting at thepeoplescooperative.org. I'm M.I. Reynolds, and this has been The People's Podcast, independent journalism of, for, and by the people. The music for this episode of The People's Podcast was Turn in the Sun by Simon Harity, used with permission, all rights reserved. The People's Podcast is produced by the People's Cooperative, based in Mobile, Alabama. Find us at thepeoplescooperative.org.